Well, good morning, and thank you very much for joining us. I am Iyori Folani. Okay, the big news last week, right up until Friday, we were talking about it and talking about the jailing for life of the leader of the proscribed IPOB, Nnamdi Kanu. That's not news anymore. But this morning, we'll look into some of the aspects. Of course, he's going to appeal. Onyedikachi Ifedi has been putting out some grounds of appeal when they move to the next court, the Court of Appeal. Okay, so that's what we'll be looking at today, including, if you want, reactions, which continue to be, fast and thick over his, being jailed. He's jailed. Our guest this morning is Dr. Tunji Abayomi. Dr. Tunji Abayomi, renowned constitutional lawyer, is in our Abuja studio. Good morning to you, sir.
Good morning, Mr. Folani.
Yes, sir.
And good morning to your audience nationally.
Indeed. Well, the matter needs very little introduction because he's been jailed for life, was found guilty of all but 2 of the 7-count charge. And the 2 charges that I accepted just now, he will be serving those sentences concurrently. But I suppose attention has to now shift to the actual crux of the matter, which is the appeal. Now, I was just paraphrasing one of the Nnamdi Kanu's lawyers, Onyedikachi Ifedi, who has said, among other things, that the Supreme Court decision to allow the trial to resume, it's been described as what has been referred to in quotes as judicial mutiny. I'll come back to you for that, what that can mean, judicial mutiny. Additionally, the African Charter on Human and People's Rights has been violated in the case of Nnamdi Kanu. Maybe could you explain to us what it is, what lawyers mean when they talk in that form, talking about judicial mutiny against the Constitution?
I do not, well, good morning again. That sounds preposterous in my view. I mean,
well, allowing the case to continue. He had been, as you know, he had already been discharged and acquitted before the federal government appealed.
Yes, it was acquitted. The case was discharged in the Court of Appeal.
Okay.
And the federal government exercised constitutional right to appeal. And it did appeal to the Supreme Court. And the Supreme Court held that the fact that it was brought to Nigeria illegally does not invalidate the right of the federal government to prosecute him, and that the prosecution can go on. And then the Supreme Court also corrected one of the counts that it was brought under a wrong law, Criminal Code Act,
okay,
and said it should have been brought under Customs and Excise Act. Now, you are now talking of judicial mutiny. What's mutiny there? Nothing is mutined. The Supreme Court, that sounds very funny to me. Any Supreme Court anywhere in the world is a god of law. And you don't go beyond that, either downstairs or upstairs. You stay stoically on that law, and it's binding on all citizens, institutions, as well as the parties before the Supreme Court. So for a lawyer to talk of judicial mutiny in itself will be considered in our profession as an act of irresponsibility under the code of practice. So there's nothing like judicial mutiny at all.
Okay. Okay, because according to the lawyers, the Supreme Court's decision to allow the trial to resume is what they described as a judicial mutiny against the Constitution. But you've just said that you don't know what that means as a lawyer. Well, thank you for that. But then how about the other matter of an alleged lack of jurisdiction? The trial court allegedly lacked jurisdiction. What do you say to that?
Well, you see, a lot of people and many lawyers also fail to understand the concept of jurisdiction. When you're talking of jurisdiction in law, basically, you're talking of two types. There's what we call jurisdiction in personam, that is jurisdiction over the person, and jurisdiction in rem, and that is jurisdiction over the subject matter. Now, in a criminal case, if you are in this country, as long as you are present, I'm talking of the presence now, in Nigeria, and you commit a crime, regardless of how you got to Nigeria, a high court can exercise jurisdiction over your person. In terms of jurisdiction over the subject matter, that is always given by the law. As I have argued, in some of my works, there's a difference between judicial power and jurisdiction. Whereas judicial power of the superior courts are co-equal, as is established in Section 6 of the Constitution. The judicial powers of the Federation shall be vested in the courts established by this Constitution. And those courts are established up to the High Court. But when it comes to jurisdiction, it's diversely invested in the courts. For example, the Supreme Court cannot try a terrorism violation, terrorism charge, because it does not have jurisdiction to do that. It doesn't have the subject matter jurisdiction. Now, to say that the High Court cannot exercise jurisdiction, well, I assume they're talking of either subject matter jurisdiction, and the law invests on that court the subject matter jurisdiction over that case. When we talk of subject matter jurisdiction, we are talking about the case, the charge. Or if it is jurisdiction in personam, that is over the person. Obviously, he's in Nigeria, he's brought to court. If it's not in Nigeria, it wouldn't have been brought to Nigerian court. So once it's in Nigeria, the High Court, Federal High Court, because of the nature of the case, can exercise jurisdiction over his person. So the argument that the court has no jurisdiction, in my considered opinion, is not in consonance with the law.
Okay. Is it
non sequitur?
Okay. Is it relevant that what is referred to as well, lawyers have these very quaint ways of expressing these things. Unlawful rendition. In short, he was brought to Nigeria not in a regular fashion. So that is what they're talking about. So I wonder, that is what they are basing their whole lack of jurisdiction on, but you've explained, some aspects of it just now.
Well, that one has been settled by the Supreme Court. The issue before the court is a criminal charge under Terrorism Act, I think it's 2013. Terrorism Prevention Act 2013. The issue is not whether he was wrongly brought to Nigeria. If he was wrongly brought to Nigeria, I think what you can do is initiate a civil action. Obviously, you cannot charge Nigeria to a criminal court. You can initiate a civil action if you can prove that his rights have been violated. But let us remember that when he escaped, he left Nigeria in violation of his bail terms. The court granted him bail subject to certain terms, and he violated the terms of bail. That's why he was returned to Nigeria to face trial. The way he was returned to Nigeria may be inconsistent with the rights of citizens. Well, that's a separate issue from what was before the court. So, and that cannot invalidate or defeat the criminal process to which he was subjected.
So following directly from what you have just explained, where does his own opportunity for redress in that instance, where is that to come from? The fact that even if one is conceding that he was irregularly brought to Nigeria, but as you just said, that nevertheless does not obviate, the criminal matter. Does that mean that it has been, that matter has been dealt with in that form?
The issue is very important to understand that the Supreme Court or any of the courts, including the Court of Appeal, they were not saying he could not be brought to Nigeria. If you violate your bail term, you can be brought back to the country where you are charged to court for criminal offense.
All right.
However, there are processes you can apply to the country where you are to repatriate you to the country where you are facing criminal charge instead of forceful transfer. Basically, what the court is saying is that the federal government must follow the process of law instead of the process of force. Basically, the end itself is valid, but the process of achieving that end is problematic in the sense that it wasn't in conformity with the due process of law. But having been brought to this country, whether unlawfully or lawfully, or whether he can be brought to this country, certainly he can be brought to this country by any law, anywhere, in any nation of the world. If you commit a crime in a country and you run to another country, you will, by international legal process, that country where you committed the offense can request that you be returned for trial. The only issue here is that instead of for Nigeria to make a request to Kenya, he decided to exercise self-help. And that's what the court is talking about. Not that it cannot be brought back to face trial.
Okay.
So to say that because it was brought back, the court has no jurisdiction, that's nonsensical in law.
Okay. One moment, sir. Let me just say that there's a live transmission, TET Fund Town Hall meeting that is holding at Radisson Blue, Ikeja, Lagos, and we'll be cutting over there. But of course, you know by now, please, you can keep on watching us. Go to our YouTube channel, and we'll still be together. As for those in the diaspora, they have not had any interruption at all. Thank you very much, Dr. Tunji Abayomi, constitutional lawyer, who is our guest this morning. And, okay, Matthew is on the line. Good morning, Matthew. I'm afraid I might have held on to Matthew for too long, so I've lost Matthew. Well, maybe he'll try again. So thank you very much, Dr. Abayomi, explaining these things to us.
Yes.
How about the matter, another, legal sort of expression, talking about double jeopardy. They, his lawyers, are saying that Mazi Nnamdi Kanu will be suffering, a double jeopardy because of his adoption and transfer to Nigeria, which are deemed unlawful, which you've just finished speaking on. So that principle of double jeopardy is as fine a time as any for Nigerians to know, that is, non-learned Nigerians to know what exactly is double jeopardy.
Well, when you're talking of double jeopardy, you must first ask the question, what is the first jeopardy before it is doubled? There's no double jeopardy. Double jeopardy can only arise if after he has been tried and convicted on this charge, he's taken to court again and charged on that same offense or offenses. There is no double jeopardy. There hasn't been a completed criminal trial.
Okay.
So I do not know what that means.
Okay.
In law, I do not understand that.
So it cannot be that the matter
hasn't been tried. There's no double jeopardy. I can tell you that categorically.
Okay. So it can't be reasoned that, well, he had already started the process and it had been sort of stopped, that the Supreme Court allowed it to resume by making those corrections. That is what perhaps is an aspect of the double jeopardy they're talking about. But, sir, let me just bring on Chris in Abuja. Good morning, Chris.
Hello, Mr. Yuri.
Thank you for calling in.
Yes, I think the point being made from the report we have is that the Supreme Court ordered the resumption of trial, what they call de novo. Are you with me?
We can hear you.
And then the resumption of trial commenced in 2024. At the time, the Crime Prevention Act of 2022 wasn't what we have. The trial, the prosecution now was referencing the Crime Prevention Act of 2013 and not the Crime Prevention Act of 2022. I want you to take note. The trial resumed 2024. And the point, the Crime Prevention Act of 2022 was in place. So why would the prosecution be referencing Crime Prevention Act of 2013? When the current law at the time prosecution commenced in 2024 was the Crime Prevention Act of 2022. I hope the learned counsel is online. Hello?
Well, yes. Thank you very much. Are those your? That's it, because Dr. Abayomi heard you. Okay. Thank you very much.
I think
Chris, thank you very much. We got you. We got you. So we'll let the lawyer respond now.
I think what I understand him as saying, he is asking why the case was charged under the Terrorism Prevention Amendment Act of 2013. I think that's what he's saying. Is that what he's saying?
Yes.
Yeah, so that's what the charging authorities, that is to say Attorney General of the Federation Office, perceived to be his offense, that he committed terrorism. And the law, the act that deals with terrorism is the Terrorism Prevention Amendment Act of 2013. Obviously, that act could have been amended. You still refer to it as Terrorism Prevention Amendment Act. The act was enacted in 2013, notwithstanding subsequent amendments. That's why it's called Terrorism Prevention Amendment Act, Amendment Act of 2013. So the issue is, in my view, I think people misunderstand this issue. The point is this, and this is a very serious lesson, especially for big people, people that are politically exposed. When you are in court, particularly when you're facing criminal charge, you are an ordinary person. The court does not recognize extraordinary personalities. It recognizes citizens. You need to behave yourself, argue your case properly, defend yourself, and put your case before a judge. In my view, Kanu trivialized the whole process. I think he focused too much on his importance instead of focusing on his unimportance before the law. You can imagine a situation where he had so many lawyers, he kept fighting them. I think almost 4 judges or even 5 at one point or the other were involved in this trial, and he kept attacking those judges as biased, and he kept transferring the case back to the chief judge, who would then reassign it to another judge. The same way, he kept dismissing his lawyers, including many of top lawyers, until he decided to defend himself. When you need an expert, it's like a patient telling the doctor that he's going to treat himself. So to bear the consequence.
Okay, so that might have been a faux pas on his part. I don't know. It's a matter of opinion, but he did decide to get rid of his defense team, and you know, unfortunately, I think it is thought that he didn't actually enter a defense, that he missed a golden opportunity to enter a defense. But in the meantime, I don't want to lose Mr. Joshua in Irewolede. Good morning to you, sir, and thank you for holding on.
Okay, thank you very much. And I greet your guest.
Dr. Tunji Abayomi.
We all saw what transpired. So I would appreciate the fact that he's marshal for us as Nigerians. You see, the times we are in are very, very delicate. First, I commend that judge. He's a courageous man. He's a courageous man. And he taught us a lot of lessons in civility and being in calmness. I mean, you have power of life and death in your hand, and somebody is treating you like a nobody, and yet he maintained his calmness. I commend him on glory. And I wish that somehow, because Nnamdi Kanu is still a human being, no matter what he thinks he is a human being, one person out of billions of people in the world. So I wish he would have that soberness of attitude to imagine the magnitude of what he has done and probably still reflect. I don't think all hopes are lost on him, but I think he should have a deep rethink about his attitude somehow. My key point on Guyori is this: please use your platform to help Nigerians. I don't know what the government is doing, especially the information minister. You see, the social media is toxic on Guyori. Social media is toxic. That is where they are changing narratives and cooking up things. And it seems like government is just waiting for fire to burn everybody. Before, Lai Mohammed would have come to your platform, he would have talked about things. This information minister, I don't know him. He just keeps quiet there. And now you have genocide. They are talking about Nigeria in America. They are talking about, and it's all these IPOP things that created all these conspiracy theories that is weak around Nigeria, right? East, for example, aiming that is genocide, where Christians are killing Christians there. You hear in America is genocide, Muslims killing Christians in the East. Where are the Muslims killing Christians in the East? But the government should leverage on the social media and educate Nigerians. The people are very, very ignorant. And anything you give to them, they accept.
Thank you very much. Thank you very much, Mr. Joshua, calling in from Irewolede. Okay, indeed, welcome back, and thank you very much for staying with us. I understand that Chris, who called in from Abuja earlier, has called in again. Good morning, Chris.
Oh, yes, Chief Fury. Hello.
Good morning, sir. We can hear you. Please go ahead now.
Sorry, I used the wrong terminology. I ought to have said Terrorism Prevention Act. Rather, I was stating Crime Prevention Act.
Okay.
So let me rehearse my question. That the prosecution resumed in 2024 and was referencing Terrorism Prevention Act of 2013 when there was in place Terrorism Prevention Act of 2022, which has more or less overtaken the Act of 2013. Why make reference to a law an act that has been overtaken by a new one?
Well,
are you with me?
Yes.
I'm not watching you. I'm not actually watching the program.
Oh, okay. That sort of explains a bit because Dr. Abayomi has touched on this particular aspect. But go ahead and finish your submission.
My inquiry rather is this. My query is this. The trial resumed, and it is like starting afresh, what the lawyers call de novo, in 2024. And the substantive law, the extant law in place was the Terrorism Prevention Act 2022. What I understand is that in the old charges, they were making reference to the law in the 2013 Act. Why would it be so?
All right. Well, thank you very much, Chris. Appreciate you.
Well, I do not know if terrorism prevention, if terrorism prevention Amendment Act of 2013 has been abolished. I am almost convinced if in fact it's been abolished, the Attorney General will not bring a charge under it. It is, of course, possible that the Terrorism Prevention Act of 2013 was amended in 2022. Therefore, it will still be Terrorism Prevention Amendment Act of 2013. In other words, subsequent amendment does not change the fact that the act was brought into law, the bill was brought into law in 2013. So I don't think that is a major issue. Now, in terms of starting de novo, you will recognize that Kanu kept challenging the impartiality of the judges. And no judge, or at least nearly all judges, once you raise issue as to their impartiality and you accuse them of bias, they will naturally recluse themselves, as it is said, from going ahead with the case. The effect of that is that when the case goes to another judge, it will now have to start de novo. You know, this is not a case of a judge retiring. It is a case of a new judge taking over an old case. The new judge will start the matter. You will remember that the case actually commenced initially in 2021. Then Kanu appealed to the Court of Appeal and thereafter to the Supreme Court before the Supreme Court said, go ahead with the trial, directed the High Court to proceed with the prosecution. And that is why the matter started in 2024. I think it started in March 2024, thereabout. You know, but Kanu decided not to defend himself. He was called to defend. He said he doesn't. This is the same gentleman who had listed a number of vital citizens, important personalities, as witnesses. Then, in fact, we are talking of a case in which his lawyers had in fact cross-examined the witnesses of the prosecutor. And it was after that, I think they made no case submission, I think, and then the court refused and then directed that he should go ahead and defend himself. Meanwhile, he sacked all his lawyers, took up his defense, and refused to defend before a judge, attacking the judge that the judge does not know law.
He does not know the law.
Well, he does not know the law, but he knows the judgment. And he is the one that will give the judgment. So if you think he does not know the law, if you think a judge does not know the law, you don't tell the judge in his court that he doesn't know the law. You go to the Court of Appeal in exercise of your right of appeal.
Okay. No, Kanu was unruly, no doubt about that. But that has been put down to, you know, maybe as a human being, as a frustrated person, he said certain things, but I have heard commentary along the lines of those things are not things that people should zero in on. Rather, they should be zeroing in on the principle of justice and fairness. That's the way it was stated. These are not my words. But I just want, let me just quickly, somebody called in from the UK. We didn't get the name properly. Is it George in the UK? Who is the
Philip from the UK? Philip, F-E-L-I.
Philip. Did I get your name right? Is it Phillips from the UK? I can't hear you well.
Yes, I'm calling from UK. Philip, can you hear me now?
Yes, except for your name.
Can you hear me?
Yes, we can hear you, but not your name.
My name is Philip, F-E-L-I-S. Yes.
Okay, Felix. Felix, okay, thank you very much. Please go ahead with your observation or question.
Thank you very much for allowing me to contribute on your Regarding the issue of Nnamdi Kanu, I think the whole thing is circumstantial. It is not addressed properly in the court of law. I think, to be quite honest with you, the 5 counts of his charges was mainly for the NGO Biafran setup, which is not, never said much against terrorizing anyone. He never used that religion to terrorize the nation. They had never terrorized any nation at all. And to bring a man, an innocent man, and get those kind of charges, it's outrageous. It's absolutely no.
All right. Felix, I want to thank you very much. We've heard, that in your view, the whole affair was outrageous. We've heard. Thank you very much for calling in on that matter. Because one of the things that Mr. Joshua in Irewole Day said was that people, are just going on and on about it in the public space, especially in social media. And that's one of the reasons why we wanted to invite an expert such as Dr. Tunji Abayomi, who is a constitutional lawyer, to sort of clarify these things so that by the time you go back to social media and you're looking at it, at least you've had the benefit of being an expert. Not that I'm referring to anybody who has called in here, but I don't know how many experts there are on social media to be moving the conversation along. Okay, so there is that, sir. First of all, Felix has come on top of the other question, the other person who called. Yeah, it was indeed, I think it was Mr. Joshua in Irewole Day who had called in. But let me just jump forward a bit now, and there's a curiosity. The judge said in sentencing Kanu that even though the charge called for the death penalty, he was going to show mercy and cited biblical, provisions that sort of encouraged him in that direction. He said, among other things, that the death sentence is not very popular anymore anywhere around the world, and that he would have mercy. It turned out, in the final analysis, he had said that, Kanu, you will go to jail for life. I will not order your death. Is the judge at liberty, or is the law cast in such a way that you have to follow the provisions, right up to the sentencing guidelines?
Well, there are a total of 7 counts, and I think about 3 of them, or thereabout, or 4, carry mandatory death sentence. Basically, these are convictions on terrorism, found guilty on terrorism. But the court is at liberty, I think, to sentence him to life imprisonment instead of death sentence. But here is the situation. The Kanu, I do not know if he will take a lawyer now. If he appeals to the Court of Appeal, he runs the risk of a cross appeal by the state, by the federal government, that his conviction should in fact have been death, according to the provision of Terrorism Prevention Amendment Act, under which he was charged. So that's just the only issue. I think at the point we are now, if I were to advise, I think what will be beneficial to the convict is maybe an appeal to the prerogative of mercy. I think it's 174 thereabout of the Constitution. The president can't, in exercise of his power, grant retrieve either conditionally or unconditionally to Kanu.
Okay. Okay.
But as it is now, you know, I think it's Plato who said uncontrolled justice or injustice has to be handled with care. He needs to be very careful now, having brought up upon himself, in my view, a conviction that perhaps peradventure could have been avoided.
Okay. Okay. Mazi Okorafor, thank you for holding on. Go ahead, sir.
Good morning, Sayuri. When I saw my brother on television yesterday, all this was talking about the actually action. When they asked him about the Nnamdi Kanu. First, there is nothing wrong. Sokoto prison. His guardian of blessed memory was there. And he came back successful. Nnamdi Kanu went there. It's not a new question. But the question is, the judgment has come. I still hanging. Hanging in the sense that we have a Supreme Court, we have Supreme Court. And my OG said that all Jews of study yesterday that they will appeal. That the same thing, the honorable members also appeal to the president on that. But what I want Nigeria to do is what that our judicial system. We have to follow things sequentially. Whether you're a lawyer or you're a lawyer, whether you're a judge or not a judge. If anything the Constitution is talking about a particular crime, let us follow it sequentially with proof of evidence. Because if you say that you got a thief or anybody, go to police station, they will tell you any proof. By the time they take it to the court. But the situation whereby, when you call the witness to come, if they said they are sick, they are not available, that is what makes Nigeria start doubting the judgment. But there's nothing wrong. The judgment has been passed, but the question is the same. Anybody comment anything you are doing wherever you are, make sure you are doing the right thing, because at the end of the day, you are probably able to come back. But the judgment you speak today is the same thing that appeal by tomorrow. Another court proceeding. Somebody will come and say, so case or so, section this is on the subsection A, this is the same thing that is applicable everywhere. But the question is, any judgment, let it be according to the Constitution, not biased. Not based on safety statement or just because people say so. But this was quick for the Supreme Court and for the Appeal Court. I was very happy against the Eastern Nigeria. Everywhere is calm. People are going for the normal business like the day that is Sunday. People sit down, want to go to the farm, they go to the farm. Nobody wants to see. Tuesday, nobody duty continues. But the thing is that let us take the way things are going on. But our major problem now is security of everybody is paramount important. Anything against the rule of God is vanity of our vanity. Good morning, my brother. Good morning, Nigeria. That is better than
well, thank you very much. Dr. Bayomi, you spoke last about the prerogative of mercy possibility. Now, does that, there are many, eminent Igbo men, Igbo leaders, who have said that they were expecting that the outcome of all of this would have been a political solution, not what we have now. Now, I don't know, what do you understand, apart from the president, dispensing his, right, to, what is it, the prerogative of mercy. They were, many Igbo leaders have said that it's a political solution that should have been found. What are your views on this? And I think you hinted in there that it has to be applied for. So I wanted to know, must it be applied for, or is the president, in this case, President Bola Ahmed Tinubu, just to get up and say, look, following my own reasoning, I'm not listening to that plea, or following my own reasoning, I do want to grant the prerogative of mercy on Nnamdi Kanu?
Well, that's entirely the prerogative of the president. And that prerogative is not subject to any conditions. The government can grant that prerogative, pardon, conditional pardon, or pardon without condition after conviction. No president, in my view, will interfere with a case that is in court. Usually, when a trial is going on and you want to discontinue that trial, the Attorney General is empowered under the laws and the Constitution to exercise what is called nolli prosecutio.
Yes.
That is to say, we are not prosecuting. It is the prerogative of the Attorney General while the case is in court. And you know, the Attorney General is a minister, an agent of the President. If the President is interested in discontinuing a prosecution or a case, he can then direct the Attorney General to enter what is called a nolli. Once there is already a conviction, that is not applicable anymore.
Oh.
You can now turn to, yes, you can now turn to prerogative of mercy after conviction. That, of course, will make an appeal unnecessary and unwarranted once the President grants a prerogative of mercy. That could be a political decision for whatever reason. It is the right of the President, the privilege, I would say, constitutional privilege of the President. So I discuss this in my book, Powers and Duties of the President. For those who are interested in studying more on this in this area.
Okay, well, be that as it is, we've heard it's not so much a maxim, maybe it is even a maxim, that the rules of justice are sometimes, if not most times, grind slowly. In a case like it,
I believe in 2020. I believe in 2021. Then, of course, there was another delay before ultimately the trial had to begin in March 2025. So a lot of times, for example, you look at a situation where he was sacking his lawyer all the time, or sacking his judges, literally objecting to the presiding authority. He was accusing the judges of partiality. And no judge will continue. So a lot of the delay, and the case, so I think it started around 2015 or thereabout. In court. So we've been there for 10 years. Going up and down, but largely due to his intervention many times, because basically I think he didn't really want the trial to go on.
So we're going to have to, I'm going to take it that it's difficult to call it in terms of how long it might take. There are so many other factors. But I do want to thank you, Dr. Tunji Abayomi, for shedding light on some of these issues and at least discussing them again. Of course, we, along with the whole news media in the country, are going to be following this very, very keenly, no matter how long it takes. But once more, Dr. Tunji Abayomi, thank you very much for coming on our program.
Thank you very, very much. A lesson for big people. Get a lawyer to defend you. Thank you.
Then. We're going to have to leave it there. Thank you very much, Dr. Tunji Abayomi, constitutional lawyer. Okay, do please join us tomorrow for a fresh edition of the program. I am Yori Folarin. Bye-bye for now.